লাইভ না যখন স্টেজে লোক চলে আসবে ওরা লাইভ করবে, ঠিক আছে? রেকর্ড করতে হবে।
Announcement for everyone in the auditorium. If you can please switch off your cell phone or put the cell phones in silence mode. This is an announcement. This is an announcement for everyone in the auditorium. If you can please switch off your cell phones or keep it in silence mode before the guests arrive. Thank you.
Hey, camera. Sir, good morning, sir. Nischay, sir. সিঙ্গেল সিম তো আমি তো করবোই, বললে আমি না বলবো, আসবোই। হ্যাঁ, এই লোকটা বলি না আমি খাবো, আমার ইয়ে না একদম বলবো না। শেষ বেঞ্চি বসে আছি, বাড়ি ঢুকে গেছো? বাড়ি যাও।
सर वही तो है आइंदा जो ढूंढ भी
बोलो तुझे जो है तुझे बोलो ना 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 रेस रेस वाले तो वो फैशन जॉब रेस হবে रेस আর তো ওদের ফ্যাশন শো যেটা ছিল না ওদের আগের দিন হয় না ফ্যাশন শো ওই ফ্যাশন শোটা হচ্ছে না মেটাল পাওয়ার হ্যাঁ
It is the 15th of December, almost the year end, a Friday morning, almost a weekend. And though the weather outside is cool and pleasant, we have gathered here for a heated discussion, debate and exchange of ideas and opinions, especially after the pandemonium-creating G.D. Birla case. Today, we have gathered here for a workshop on Juvenile Justice Act 2015 from paper to ploy, which is organized by the Kolkata Police Law Institute under the aegis of Kolkata Police, much upholding its motto, "We care, we dare." We have with us today as the chief guest Dr. Shashi Panja, Honorable Minister of Women and Child Development and Social Welfare, Government of West Bengal. Our guest of honor, Professor Dr. P. Ishwara Bhatt, Vice Chancellor of the West Bengal National University of Juridical Sciences, Kolkata. Our special guest, Honorable Justice Ranjit Kumar Bagh, and Chairman of KPLI, Kolkata Police Law Institute, Learned Commissioner of Police, Shri Rajiv Kumar, IPS. May we please have a big round of applause for these esteemed dignitaries on stage. For the said purpose, we have these eminent personalities of the city here with us on stage, and it is indeed our proud privilege to felicitate them to mark the beginning of the inaugural session of the workshop today. Ladies and gentlemen, a big round of applause for the dignitaries on stage, please. We are extremely grateful to have all of you with us today, indeed, and in spite of your busy schedule and prior commitments. Lighting of the lamp is an Indian custom held in high esteem because it implies the solemnness and integrity of any occasion. Hence, I would like to invite all the distinguished guests on the stage to light the lamp and initiate the opening of the workshop in the Kolkata Police Auditorium on Juvenile Justice Act 2015 from paper to ploy. My heart leaps when I behold a rainbow in the sky. Child is the father of humanity, quote unquote, William Wordsworth. Hence, ladies and gentlemen, we give consent to the fact that children should be taken care of and protected legally in an era of globalization when everything and everyone gets treated as a commodity exchanged in the marketplace of social milieu. Within this social context, the Juvenile Justice, Care and Protection of Children Act 2015 receives the assent of the President on the 31st December 2015. So soon we'll be completing 2 years of it. It is an act to consolidate and amend the law relating to children alleged and found to be in conflict with law and children in need of care and protection by catering to their basic needs through proper care, protection, development, treatment, social integration, by adopting a child-friendly approach in the adjudication and disposal of matters in the best interest of children and for their restoration and rehabilitation through processes provided and institutions and bodies established. With this briefing, may I please vacate the podium for our Chief Guest and Honorable Minister of Women and Child Development and Social Welfare, West Bengal, Dr. Shoshi Panja, to share a few words on her experiences of working with the juvenile justice system. A big round of applause for Dr. Shoshi Panja.
Good morning, everybody, and what a wonderful initiative, what a wonderful program organized by the Kolkata Police Law Institute, and on such a relevant topic. This would never lose its relevance when we discuss about juvenile justice, care and protection of children, when we discuss the Act. Especially today is 15th December, and when I think of 16th December, tomorrow is the date a few years back when we had the Nirbhaya Kand, the Nirbhaya incident. So, of course, we offer our, I would say, our regards to that fighter, Nirbhaya. But following that, we have seen that there has been a lot of changes in how we address the crime, etc. And very well organized from paper to ploy. I would thank Sri Rajiv Kumarji, Learned Commissioner of Police and the Chairman of the Kolkata Police Law Institute. It's always an honor to share the dais with Honorable Justice Ranjit Kumar Bagh and also Professor Dr. P. Ishwara Bhatt, the Vice Chancellor of the West Bengal National University of Judicial Sciences. And in fact, we do have collaborative programs between our department and NUJS on various such issues. Thank you to the teacher in charge of the Kolkata Police Law Institute, Dr. Ayan Kanti Chakravarti, and his entire team. I know they have been really working very hard, and they have also been requesting us for various hand-holding books or journals or various papers that we prepare from our department as for dissemination of the knowledge as far as this act is concerned. And also, I take this opportunity that I'm really happy also to see many officers in charge today in the audience, and also many students who are here attending, and many members of the NGO, and also other very familiar faces to me. I took this opportunity, I was asking the Learned Commissioner of Police exactly, I don't know how long I'm supposed to speak, but your teacher in charge gave me an impression that yes, you would have to address a little bit longer, but then I will try to make it short. Actually, I did prepare some presentations, which I would hand it over to Dr. Chakravarti today, because this may be utilized also for their discussions and during the classes. There is also a handbook on child protection committees, which the department is working, child protection committees working right up to village level, and a handbook on how it functions, because it means child protection, it means child security, it means how to handle trafficking in the districts or even in Kolkata. So that is a handout which we have already given. I just have brought out today I brought with and I will send it across. It's a handbook which is on the West Bengal State Plan of Action for preventing and combating human trafficking in women and children. I will also be later on sending this, which as usual I took this opportunity because if we have the officers in charge of various police thanas and also respective DCs, this is also a very important thing which we need to address from your level, and that is the Domestic Violence Act and its proper implementation. So this is actually basically what we have brought is things that we expect from the police and how they would perform vis-a-vis this act, that is DVA. And this handbook has also a portion which defines the role of the police. So this was something which I really wanted to demonstrate. Now, regarding the Juvenile Justice Act, which came out in 2015, followed by the central rules, and then we are happy to say that very recently it was laid in the West Bengal Assembly, and that was the Juvenile Justice rules from the state. The state has to lay the rules, and only then we can actually implement the act. So that was dated 15 September 2017. There is a Gazette notification. So we are ready to act upon the rules which have been laid out and defined. I think you have a set of this copy too. Maybe we'll send this across because the rules are very important. Basically, I think since you have been talking about it or reading about it, we know the basic features or the basic difference between the previous act and the new act. But what really, the demand is such that it says that the percentage of juvenile crimes as a proportion of the total crime has increased from 1% to 1.2% from say 2003 to 2013. And especially the age group, 16 to 18, which we are all very worried about, following that Nirbhaya incident. That's the 16 or the 18-year-olds accused of crime as a percentage of all juvenile or child accused of crime has increased from 54% to 66%. So most of this increase, this enhancement, it was 54% before. The 16 to 18-year-old involved in crimes, that has increased to 66%. And that's why it makes it very much important that we discuss this. Because the key features of this JJ Act also has addressed this group, and also when it says about children in conflict with law and the offences committed by a child below 18 has been categorized in 3 separate ways, that there are heinous offences or serious offences or petty offences. And of the petty or the serious offences, as it says, that those are, say, petty offences is something just below 3 years of imprisonment, or serious is, say, between 3 to 7. But the ones which are the heinous ones are those with minimum punishment of 7 or above. Now, this is, as I said, pursuant to the incident which happened on December 16th. Because the restrictions of the old act was that child, irrespective of his crime, would have spent maximum 3 years in an institutional care, the special homes that we have, and would not be tried as an adult or even sent to jail for that matter. So when we talk about the new act, we talk about this category also, and how important it is that in the heinous crime that we were talking about, that it is now up to the JJ board, of course, this is for our knowledge too, that the JJ board would actually assess if the crime committed as a child, was it committed as a child, of course committed by the child, but was it committed as a child or as an adult? So that is where they take comments, or they would take the expertise of the psychologists or the social experts, and then the trial of the juvenile would take place on basis of this assessment, whether it would be a routine as you would assess a child, or you would take it as a case, adult case. And under section 18, subclause 3, that after preliminary assessment, the board may order the transfer of the child as an adult, and then the board may transfer even the case to the children's court. So that, as you know the definition of children's court, which I really don't want to. So this was one very important thing which happened in this act, and which we have been incorporated in the rules accordingly. When we talk about the police, something which we really look up, there are certain terms which we introduce, of place of safety. Now, our departments has notified certain homes as place of safety. What you do at the dead of night when you get a child. So there are places of safety which we have notified. We will share from the department later on. Certain terms like fit facilities or SAR, which you have to be aware of. Children's home, of course, you know the CCIs. The open shelters, which we have again in our department. The observation homes and the special homes. Certain such terms which you have to be familiar when, and you would be discussing in your workshop also. What we are concerned, and basically all said and done, being a member of the Legislative Assembly and a representative of a constituency, and you have day-to-day problems of people approaching you, mothers, parents approaching regarding their children, and lots of a variety of cases. So it is very important that we have a child welfare police officer, a CWPO, and a special juvenile police unit, section 107. So in every police station, at least one officer, not below the rank of the... This is a kind of an exercise, a workshop is a kind of an exercise where we learn, of course, but also we again revise that there has to be one officer not below the rank of an assistant SI who may be designated as the child welfare police officer to exclusively deal with children either who is a victim or a perpetrator. Now that is what we are facing. Either the child has committed a crime or is a witness to a crime. So a CWPO becomes, PO is very important. And to coordinate all such functions of the police related to children, of course, the state government constitutes the SJPU in every district, and that would also include railway police who will deal with children. That point is again very important. Again, where the law, the act again comes into the apprehension of a child who is alleged to be in conflict with the law. This is also very important. Of the section 10 of the new act, which is a replica of the section 10 of the repealed one of 2000 act, which provides that as soon as a child in conflict with law is apprehended by the police, this child will be placed under the charge of the special SJPU, that is the SJPU, or the designated child welfare police officer, who shall produce the child before the board within 24 hours. Now, this is also very important because it now also says that if you may not get the entire board, even if you have one member of the board, that production is also allowed. So that is very important, that the timelines are very important. You see, that's where we get delayed. We may designate somebody as the child welfare police officer. One thana does have it, the other thana doesn't have it. So we live on borrowed personnel. We know that. But again, sometimes it goes beyond 24 hours. So that is also a timeline that we have to observe. But again, it says it excludes the time necessary for the journey, and in no case, it's very important and you know it, I'm just repeating it, that the child will never be placed in a police lockup or in a jail. And thereby we are talking about the child-friendly, that comes in also, that become child-friendly police stations come into the discussion. And I guess that the child police, the police where we have these child-friendly structures or this child-friendly environment, there are about 26 indicators which has been notified even by the Department of Home, Government of West Bengal. So these 26 parameters are looked into when we actually establish a child-friendly police station. Now, another point that is one is that about a child when he is brought, what is the duty of the police on immediate apprehension of the child? If the child is in conflict with the law, CCL in short, the police has to produce the child before JJP. Okay, a child in conflict with law may be produced before the individual member of the board, as I was mentioning, if the board is not sitting, and presence of two members is needed, of course, when you make the order under section 18, subclause 3. In case of difference of opinion, the opinion of the majority will prevail. This is, though it relates to the board, But the duty of the police that is the way I just wish to highlight the points and when I made this presentation. And if the child is in need of care and protection, the child will of course produce before CWC. It is happening, but I guess we need to, as I said, we need to check on the timelines about production before CWC, and we also, since CWC is also related to our department, we have our sensitization workshops even with CWC to also, impose upon them. To a certain extent, it is imposition that timelines have to be maintained. I'm not getting into the details of who is the child who is in need of need of care and protection, but then again, this is the entire domain that we look into, even the OCs of the thanas and various divisions. They're the homeless, the abandoned, the street child, the forced labor, the beggar, the abused, tortured, neglected, exploited, mentally or physically challenged, mentally or physically ill. Incapacitated parents are there, or no parent of a child, missing or a runaway child, whose parents are not traceable, abused, as I said again, vulnerable because of drug abuse or trafficking, abused for certain other gains, or victim of natural or man-made calamity. When we had Ayla, or when we had the earthquake in Nepal, we had such children who were even trafficked at that particular point of time, and we have been dealing with those children. So who can produce CNCP children before the committee? So as we said, that again, since I was trying to define the role of a police officer, so police officer is one of them, or of course the Special Juvenile Police Unit, who would produce the CNCP child before the Child Welfare Committee. There are others also, there are other stakeholders too. I'm not going into it because we have CWO, we have the PO, we have the Child Line Services, etc. When we, this is something which I'm running through, but there is something which the other day we have a state advisory committee on trafficking, and the state advisory committee has various stakeholders on board. It includes human rights, includes the Department of Home, it includes health and family welfare and education, and everybody, and of course we are the nodal department. In that, a very important discussion came in which it is mentioned that we understand that the DCRB sits with the DCPU, or rather we were encouraging that at the district level to handle trafficking, DCRB, DCPU, the District Child Protection Unit, the SJPU and the Child Line should sit for a monthly or a bi-monthly, I believe the DCRB sits, and they have to have a combined meeting because to maintain that liaison. This is where, due to lack of coordination, sometimes we do not get the data, or sometimes we do not get a platform to place our data. So this is something that we are working on, and which I need to I need to pass on this information to you. Even at the subdivisional level, when there is a subdivisional police officers meeting, we are encouraging the Child Line, the DCPU should be also incorporated in those meetings so that there is a very good review and a very good coordination between them. We have decided on a very important monthly meeting between Child Line, UNICEF, the HRC Human Rights, our department, SCPCR, and the State Advisory Committee, so that we again can review with the Home Department, with the police, about the status of anything. Now, some very good work has been done, especially when it comes to, when we talk about JJ Act, there are varieties of children that we discuss. So there's been very good work on by Operation Muskan, Operation Smile on missing children. So that has resulted in a very good, we have got a very positive result out of this. Besides that, of course, arresting traffickers and rescuing children and women, there was a data which was placed to us about the number of traffickers which were arrested. Now there is an issue here that about arrest of the traffickers. What is the, actually finally, how many such traffickers are really punished? Because the trafficking of children or trafficking of women or women with child, the issues of illegal migration comes in, the issue of child labor comes in. There are various related issues which come into this. So unless the trafficker is arrested, punished, the punitive measures, that is something which we were concerned with, and we share it with you also, that we have to take it to that extent. Bandhu Kolkata was one scheme also which we do during the pujas with Kolkata Police, our department with Kolkata Police and with few NGOs, which was a safety net for missing children, women and senior citizens during Durga Puja. Besides, I think the Kolkata Police having its own separate program too. We have a very good program on self-defense, where we equip the girl with self-defense skills, and that is Sukanya, which you all are aware of. So very positive things. One very practical suggestion which I have before I really conclude today, and that is that at every thanas, again to maintain that liaison, that because I'm also trying to put in domestic violence into the frame today, and that is that domestic violence as per the act will be addressed by the protection officer. But the woman actually, the aggrieved person actually first reaches a police station. But the police station, of course, makes a record of it. But there are also reports of, not taking filing reports. File reports are not filed. And the aggrieved is counseled in a way that why don't you compromise? So compromise with the situation. So that becomes a bit difficult for the lady. So here, if at the Thana we have a proper kind of a display of who the protection officer is of that district, we have a display of 1098 by now. Childline is very prominently displayed in all Thanas. So that is there. But again, say names and numbers of Child Welfare Committee, the chairperson and the numbers of the members vis-a-vis district, we have a Child Welfare Committee in place. Then there is, of course, a Women's Helpline 1091, which is used by you. The use of this 1091, that is also important. The use of 100, and there is diversion as per the problem. If there is a problem of, say, domestic violence, if there is a problem of a missing child, if there is any, whatever, of a child in distress, how one is dealing with it. That also has to be dissipated. And of course, the child welfare police officer, the name. If such kind of displays are there, either in the respective thanas or even in the district level, in railway stations, then I think it leads to a lot of dissemination, and that knowledge actually goes, because most of them are sometimes not even aware of, say, protection officers. Most of them are also not aware of who CWC, what CWC. So this kind of knowledge dissemination will again be important. Dissemination, sensitivity through Police Academy, Judicial Academy is something which we are always trying through Judicial Academy to sensitize our judiciary to handle cases very quickly. But all said and done, the JJ Act or the rules also defines the very fact that how you apprehend the child and how, in what kind of a situation you apprehend, and how friendly you are towards the child. So it is a very kind of an attitude that we have to show when we are handling the child who has come in conflict with law. This again is very important. This is in brief I really wish to cover, and of course I will leave behind the books and the journals for your perusal. I also will leave behind details of the TVA, and where this yellow page is a 2-pager, which back and front actually deals with what the police does. And actually, the maintenance orders, the protection orders, the custody orders, the various orders which the police can give in a case of domestic violence are still not being dealt with, I think, very efficiently. And even the woman is not aware. The woman is also not aware that I am, I have a right to such acts. I cannot just be thrown out of my home at the dead of night again. And I have every right to stay in the home where such violence is taking place and still achieve protection and custody of my children, and I be protected myself. She also gets an order that if you are sick or if you have been beaten so badly that you need medical treatment, the police would assist. So the police basically assists in all this. also assists in the fact that that environment remains safe till the case is taken forward. Thank you so much for this opportunity for speaking and addressing.
Thank you very much, ma'am, for that meticulous piece of information and explication of so many dimensions of juvenile justice system. Now may I please invite our guest of honor, Professor Dr. Bhatt, Vice Chancellor of the West Bengal National University of Juridical Sciences, to enlighten us on the legislation and implementation of the Juvenile Justice Act 2015 briefly.
Good morning to all of you. Madam Dr. Shashi Panja, Honorable Minister for Women, Child Welfare and Social Development, Honorable Justice R.K. Bagh, Honorable Mr. Rajiv Kumar, all the dignitaries, delegates and the students participating in this one-day workshop. The workshop is on the application of Juvenile Justice Care and Protection of Children Act 2015. This legislation has a history behind it. Of course, the making of the legislation, the considerations of human rights protection as guaranteed under Child Rights Convention of 1992 and various other aspirations work. In fact, the Constitution enacted in 1950 had provided for making a special provision for the welfare of children. Article 15 Clause 3 provides that nothing in this article shall prevent the state from making special provision for women and children. At that time, the human rights norms relating to children had not been developed to the extent that was required. But the constitution makers found it fit that there is a need to provide for such affirmative action in favor of children. There were stray provisions scattered in the various legislations, Indian Penal Code and various other provisions. And in course of time, there were new legislations enacted. Under the Constitution itself, against the practice of child labor, the state was entrusted with the responsibility of making law, and employment of children in any kind of hazardous labor was regarded as an offence, and that ought not to be practiced. It is constitutionally prohibited. Then abandonment of children or women, or putting any children into any vulnerable situation was something prohibited, or it was regarded as something inimical to the interests of children under directive of state policy. Thus, these policies were there, and these policies were becoming strong in course of time with the judicial recognition. For example, in Lakshmikant Pandey case relating to absence of norms relating to protection of children against international adoption, the court laid down certain norms, and subsequently those norms became binding principles, and we come across absorption of those principles under the Juvenile Justice Care and Protection of Children Act 2015. This 2015 legislation is a kind of a comprehensive code, because relating to protection of children in conflict with the law, or children who are in need of care and protection, and children who are going to be adopted, and children who are likely to be put into any vulnerable situation because of the offences. We come across very elaborate provisions. Thus, this legislation, unlike the earlier efforts, is more comprehensive. Of course, Juvenile Justice Act of 2000 had its own measures, but those measures were not adequate because relating to adoption or relating to registration of various organizations which are to help the children. There are no adequate provisions. Then comprehensive provisions are relating to offences against children and protection of children against those offences. Provisions were not there. Thus, there was a need for a comprehensive legislation, and legislation of 2015 is to be considered as a breakthrough in this regard because it tries to provide a full-fledged measure to combat various types of exploitations and various types of difficulties to which the students, the children are likely to be put into, and the need for making this legislation a success is something a responsibility on the part of various organizations involved in implementation of this legislation. There is the legislature, executive, judiciary. Not only that, various homes, there is child care homes or various other residential facilities in which children are to be housed. They have the responsibility. Then there is the need to integrate this legislation with the other legislations. For example, the legislation which prohibits child labor or which regulates child labor is to be integrated to this legislation. And other legislations like right to education should also be considered as something connected with this legislation. We cannot take this legislation in isolation. There is a need to link this legislation, overarch the values underlying this legislation with other legislations and other human rights values. Because when a Child Right Convention was enacted in 1992, they considered that all the rights of children are to be taken care of in a comprehensive manner and in an integrated manner. There is a need to protect the children in a comprehensive manner. Of course, when children are subjected to, say, human trafficking, or they are forced to begging, or when they are abandoned, or when they are becoming street children, or when parents are not taking the responsibility and they become destitute children, orphan children, or when there is a need for their protection. It is essential that law should come to their rescue. Law should be quite comprehensive. The procedure laid down under the law should be comprehensive. It should be child friendly. The best interest of the child shall be the measure with which the whole legal system has to consider and has to come to the rescue of the children. One important principle that is developed in a whole of family law or constitutional law or various other laws related to custody of children is that the best interest of the child shall be the paramount consideration with which the legal system has to think, and legal system has to come to the rescue of the children. In Section 3 of this legislation, we come across the paramount principles that are to be applied, general principles to be followed in the administration of the Act. As many as 16 principles are laid down, and these 16 principles highlight the central approach that ought to be adopted by the legal system towards the children. Principle of presumption of innocence. A child shall be presumed to be an innocent of any malified act. Of course, children are basically innocent people, and there shall be legal presumption in favor of their innocence, then all human beings shall be treated with equal dignity and rights. Children should be given that kind of favored treatment. Principle of participation. Every child shall have right to be heard and a right to participate in all processes and decisions affecting his interests. See, in the course of decision making relating to the child, there ought to be participation of the child. Otherwise, the decision makers will not be able to know the interest of the child's special needs or child's own views, how decisions related to the child shall be taken. Then a principle of best interest. All decisions regarding the child shall be based on the primary considerations that they are in the best interest of the child. In fact, common law system had developed that notion that best interest of the child shall be the consideration, or it shall be the principle or criterion in accordance with which decision shall be taken. Then a principle of family responsibility. Primary responsibility of care, nurture and protection of the child shall be that of the biological family or adoptive or foster parents, as the case may be. That's the natural parents or the adoptive parents or foster parents have that responsibility, and it is in the context of that kind of conducive atmosphere of family circumstance that the child's personality should grow. See, just like a seed grows into a mighty tree, a child has the potentiality of growing into the fullest dimension. The blossoming of the personality will be possible when the nurturing atmosphere is available. That's it's the responsibility of all persons who are related to the child, either in the form of giving that residential facility or providing that kind of care, or persons who are administering any policy decision under the legislation, or even other persons who are rescuing the children to take appropriate decision in this regard. Principle of safety. All measures shall be taken to ensure that the child is safe and is not subjected to any harm, abuse or maltreatment. When we come across one long chapter relating to the definition of offences against children, actually there is a elaboration, amplification of this principle that right to be safety is one of the basic right of the child. Then principle of positive measures. All resources are to be mobilized, including those of a family and a community, for promoting the well-being, facilitating development of the identity, and providing an inclusive and enabling environment to reduce vulnerabilities of children and the need for intervention under this act. Also, the child is kidnapped or compelled to beg or subjected to any kind of physical violence, like a deprivation of the sensory organs, so that it becomes disabled and it becomes a more productive resource for begging, etc. Actually, the safety of the child is at threat. There is a need for positive measures. Timely rescuing of the child and giving protection to the child becomes very much essential. Principle of non-stigmatizing semantics. Adversarial or accusatory words are not to be used in the process pertaining to a child. See, the ordinary legal system, which believes in a accusatorial method of decision making, may not be considered as suitable. That legal procedure, which is more suitable to the interest of the child, shall be employed, and paramount consideration is that the child shall be given adequate protection. The principle of non-waiver of rights. there is no such thing as a waiver of a human right, waiver of a fundamental right, especially insofar as the child is concerned. There's the Juvenile Justice Board or the Child Welfare Committee shall take cognizance of all those things. See, there are so many bodies, there's child care homes or various other institutions providing residential facilities, and these bodies are under a responsibility to protect the interests of children. That's why the legislation makes it mandatory on the part of all these bodies to undergo the process of registration. Once there is a registration, then it is possible to apply the legal measures, and there will be accountability on the part of these bodies. Now, earlier to this legislation, there was no such a requirement of registration of these child care homes, etc. Thus, if there were abuses, there was no method of tracing the occurrence of such wrongs, and after the new legislation, there is a added responsibility on the part of these bodies. They have to act with a sense of accountability. The principle of equality and non-discrimination. There shall be no discrimination against a child on grounds including sex, caste, ethnicity, place of birth, disability, and equality of access, opportunity, and treatment. Then a principle of right of privacy and confidentiality. Every child shall have right to protection of his privacy and confidentiality by all means and throughout the judicial process. See, right to dignity, right to privacy, right to personal liberty. These are all important values, and there is a lot of emphasis given to the aspects of privacy. Privacy is regarded as one of the most important fundamental right. Then the principle of institutionalization as a measure of last resort. A child shall be placed in an institutional care as a step of last resort after making a reasonable inquiry. Principle of repatriation and restoration. Every child in the juvenile justice system shall have the right to be reunited with his family at the earliest, and to be restored in the same socio-economic and cultural status that he was in before coming under the purview of this act, unless such a restoration and a repatriation is not in the best interest. Thus, children shall be absorbed into the society, and there shall not be any such a situation where the child will be feeling that he or she is feeling a sense of abandonment. On the other hand, mixing that child with the whole society becomes very much essential. Then a principle of a fresh start. Now suppose the child has committed some wrongful act. Then the approach shall be to restore the potentiality of the child to get back to the earlier situation, and all past records of any child under the juvenile justice system shall be erased except in special circumstances. Fresh start shall be given. Then a principle of diversion. Measures for dealing with the children in conflict with the law without resorting to judicial proceedings shall be promoted unless it is in the best interest of the child. Then the principles of natural justice shall be followed. Of course, these principles laid down under section 3 spread over to various provisions of this legislation, and they get support from the human rights values enshrined under Convention of Rights of Children, or the fundamental rights guaranteed under the Constitution. And we come across so many judicial decisions which have given elaborate treatment to these principles, or they have expanded the rights of children related to right to education, or a right in the context of adoption, or a right in the context of protection under the Juvenile Justice Act. The approach of a judiciary is one of expansion of human rights. It is essential that the aspiration behind this legislation shall be given adequate attention. In fact, this is a measure of social transformation. For bringing any kind of social transformation or parivartana, there is a need that the whole society should participate. There should be a concerted effort. There should be an integrated approach on the part of various participants, various power holders, various organizations or bodies who are entrusted with the responsibility of giving effect to this legislation, so that with all seriousness, with all such a commitment to the cause of better protection of the rights of children, there shall be such an application of a law. Of course, the Kolkata Police Law Institute has taken this particular step of bringing a sensitization and understanding the responsibility, the way in which this legal instrument could be supported and strengthened. In NUJS, under UNICEF support, Child Right Center is undertaking number of research activities, number of programs relating to popularizing or say training various measures through which the implementation of this law will become more effective. How exactly in all these 20 districts of West Bengal this legislation is put into effect about the functioning of Juvenile Justice Board or the working of CWC, there's a Child Welfare Committee, or about the way in which various child homes, stay homes and various other residential facilities are kept, to what extent they conform to the human rights values and various other things, and what is the experience of the society. About this first-hand information is obtained by this by the Child Right Center. Of course, it's an ongoing phenomenon. It is essential that various other institutions should also be collaborated, and there ought to be such a collaboration with the police, collaboration with the NGOs, and collaboration with the ministry, because ministry under the able leadership of Honorable Justice Shashi Pandya is doing a wonderful task in integrating various measures through which the better protection of the children will be possible. And Kolkata High Court has also a juvenile justice body, 3 judges committee is there. Justice Harish Tandon, Fateria, and Justice Somen Sen are taking and various other judges, including Justice Honorable Justice R.K. Bach, they are taking a lot of care. They are taking various specific steps and measures to make the child right more a social reality. And in this task, bringing awareness and identifying the responsibilities, knowing the law, and knowing any of the lacuna in the law, and the way in which those serious and other measures are to be properly addressed. About this one-day workshop will be contributing quite significantly. I am congratulating the Kolkata Police Institute for organizing this one-day workshop. I wish all success to this one-day workshop. With this, let me conclude. Thank you very much.
Thank you very much. much, sir, for that enlightening piece of information. I'm sure all the audience over here will take back your lecture with deep reflection. May I please have our special guest, Honorable Justice Ranjit Kumar Bagh, at the podium to throw light on the judicial dimensions and adjudication of the Juvenile Justice Act 2015. Over to you, sir.
Honorable Minister Dr. Susi Panja, Professor Bhatt, Vice Chancellor of NUJS, Mr. Rajiv Kumar, Commissioner of Police and Chairman of Kolkata Police Law Institute, senior police officers present here, ladies and gentlemen. Whenever a person is in trouble and he is confused, he first rushes to the police station without knowing what is his remedy. And it is the duty officer in the police station who will have to tackle that person. So the police officers who are working at the level of the police station, they should have an idea about the child right so that they can maintain the order of the society and protect the child rights. I must congratulate the chairman of Kolkata Police Law Institute, Mr. Rajiv Kumar, and his other associates, and Dr. Chakraborty, teacher in charge of this institute, for organizing this workshop. Now, the history of the Juvenile Justice Act and some of the intricacies of the law have already been highlighted by Honorable Minister and Professor Bhatt. Without describing about the adjudication part, I would like to point out what should be the role of the police in tackling this, in implementing the child right, which are protected by the new Juvenile Justice Act and the other acts which have been enacted by our legislatures. So the first Juvenile Justice Act was enacted in 1986 for the purpose of maintaining the minimum standard of administration of juvenile justice on the basis of the Beijing Convention. As India was a signatory to the International Covenant, so that law was enacted. Subsequently, law was changed from time to time, but the law was not found to be sufficient for protection of the child right and for maintenance of the order in the society. When India ratified the International Covenant on Child Right in 1992, it became obligatory on the part of our legislatures to enact a comprehensive legislation for the protection of the child rights, and thereby this present Juvenile Justice Act 2015 came into force, which was perhaps notified in next year, January 2016. At the same time, our legislatures also enacted Protection of Children from Sexual Offences Act 2012, which is also very important for the protection of child rights. Now, without describing the sections and rules of the provisions of law, you all know that now the juvenile means, or a child means, anyone below 18 years of age, male or female below 18 years of age. He or she is juvenile. Now, juveniles have been classified in two broad categories. One category is the juveniles who are neglected, not looked after by the guardians or the parents or by the society, or those who are orphan, abandoned. Previously they were called neglected juvenile, now they are called juvenile in need of care and protection. The other type of juveniles are the juveniles who committed offense under the law. They committed the offense, that's why previously they were called delinquent juvenile. Now the term delinquent is deleted. We don't use that term. Now we call that the juveniles who are in conflict with law. So the juveniles who need care and protection, they are dealt with by the Child Welfare Committee. In every district there is a Child Welfare Committee. That Child Welfare Committee is duty bound to look after these juveniles. Now, what role police can play with regard to these juveniles who are in need of care and protection? If any police officer finds someone who is orphan, a juvenile who is orphan, who is abandoned by parents, or a juvenile who is found to be begging on the street, or juvenile who is the victim of trafficking, or who is exploited for prostitution or pornography, or any juvenile, female juvenile, who is forced to marry against her will by the parents or the relatives, they also will fall within this category. So the police officer can bring to the notice of the Child Welfare Committee about these juveniles, either with the help of any NGO or directly, and then it is the duty of the Child Welfare Committee to look after these juveniles, make social investigation, and ultimately if the juvenile is found to be fit for adoption, then the juvenile can be given in adoption. Because our legislatures, our law enforcement agency, our judiciary, always they are in favor of protecting and strengthening the marriage and the family. We are not in favor of breaking the family, breaking the marriage. Why? Because if the family unit remains intact, if the family is strengthened, then the child will be protected. Child will be able to enjoy the child rights. So the best way of rehabilitation of this type of children is by way of adoption. Now for adoption there is a separate procedure laid down in the law. Ultimately adoption is given by the court. On being satisfied about the prospective adoptive parents' financial ability and other criteria, if those are fulfilled, then adoption is given. Now, police officers can help in conducting the inquiry if the person approaches the police. That can be done. And during the inquiry, the children can be kept in the foster care, or they can be that will be dealt with by the Child Welfare Committee. So police does not have any direct role to play there, but passive role can be played by the police in this regard. Now the real professional role of the police comes when the child is in conflict with the law. We have to keep in mind that the child can never be treated as a criminal. Child cannot be kept in the police lockup or in the jail. Whatever may be the magnitude of the offence. When the offence is reported to the police, the juvenile police unit is, I think that is notified already. So juvenile police unit will take up the case and the juvenile will be placed before the Juvenile Justice Board. The board will conduct the inquiry, and during inquiry the juvenile will be kept in the observation home. After that, a reformative punishment will be given so that the child is reformed and he can come back to the society as a free, reformed citizen and can play his role in the society. Now, police may have a problem when this type of juveniles in conflict with law are committing very heinous offence. What is heinous offence? That is prescribed in the law. Offence where punishment is imprisonment exceeding 7 years. Those are classified as heinous offence. So if a juvenile above the age of 16 years is committing heinous offence, then prayer can be made before the Juvenile Justice Board for trial of that juvenile in children's home without being dealt with by the board. Ultimate decision will be taken by the board, but the materials and information can be produced before the board, and the board will take a decision on the basis of whether the juvenile was matured enough to understand the consequences of the offence, whether the juvenile had the physical and mental capacity to commit the offence, and under what circumstances that offence was committed by the juvenile. These aspects will be taken into consideration by the board, and the board will decide whether the juvenile should be tried by the children's court or by the board itself. If it is done by the board, then the board can pass any type of order in connection with the juvenile. Maximum is perhaps 4 years detention in the special home, and there are other reformatory order which can be passed by the board. And if it is dealt with by the children's court, in that case, the juvenile cannot be tried with other criminals. He must be tried separately. And there is a limit of punishment. Death sentence can never be imposed on the juvenile. Why? One of the many criteria of imposition of death sentence is that the convict must be beyond reforms. Now, every juvenile, every child can be reformed. Due to the young age, there is possibility of reformation. That's why death sentence will never be imposed on the juvenile. And life imprisonment can be given, only that type of life imprisonment which can be commuted by the executive government. There are two types of life imprisonment. One life imprisonment is imprisonment for the remainder period of natural life of the convict. He will never be able to come out from the correctional home. But there are another type of life imprisonment which is considered under the jail code as 20 years. After commutation for good behavior, that may come down to 12 years or 11 years or 10 years. So that type of life imprisonment can be imposed on the juvenile, which can be commuted, and at one point of time, juvenile will be able to come out from the correctional home. Now the juvenile, generally the juvenile is released on bail. Generally, released on bail if there are parents who can submit the bond, if there are guardians, responsible guardians, who can submit the bond on behalf of the juvenile. But bail also can be refused if there is a possibility of exposure of the juvenile to the physical or psychological danger. If there is possibility of association of the juvenile with the known criminals, or for ends of justice, bail can be refused by the board. Now, these are the two types of juveniles which are dealt with under the present Juvenile Justice Act. It is a comprehensive code, so you will have detailed discussion in the working session of the workshop. We don't have time to discuss in detail. But in my view, there is another type of juvenile, that is the victims of offences. There is Protection of Children from Sexual Offences Act, which is enacted by the Parliament, and there are many cases against for child abuse. The offences are described as sexual assault, aggravated sexual assault, penetrative sexual assault, aggravated penetrative sexual assault. 4 categories of offences are described under the Act, POCSO. Now, the definition of penetrative sexual assault is akin to the present definition of rape. You all know that after Nirbhaya case, definition of rape is drastically changed. It is changed in such a way that commission of offence of rape can be established without medical examination. There is no need of medical examination to establish commission of offence of rape as per the present definition. Similarly, as per the present definition of penetrative sexual assault, there is no need of medical examination. If you go to the definition, then it will be clear to you. I am not discussing that in detail. There is no need of examination of any injury. There may not be any injury at all. There is no need of injury for commission of the rape. So the police officers who are investigating this type of cases, they must be aware of the definition of law, definition of the offence. And when they are asking for medical examination, if there is need of medical examination, if there is any injury in the body of the victim, only then there is need of medical examination. And when we give the query to the doctor whether rape is committed or not, then the doctor will be confused. Doctor cannot say whether rape is committed or rape is not committed. Doctor can say only that injury is found on such and such parts of the body, and according to his opinion, it might have been caused by such and such. So that is advisory in nature, and that is possible only when there is an injury on the body of the victim. There may be rape without any injury, according to the present definition. So there can be offence of penetrative sexual assault without any injury on the parts of the victim. And the officers who are dealing with these cases, they have to keep in mind that this is a very sensitive issue, and privacy of the victim and also privacy of the offender in case of juvenile must be protected. Identity of the victim, identity of the juvenile must not be disclosed to anyone. Identity does not mean only the name and father's name or other particulars or address. Identity means if the victim is a student, then in which class the student is studying, that also need not be disclosed. Disclosure can be done only with the permission of the court, and the court will never give permission for publishing it in the media. So that privacy is to be protected, because that is a right of the child, that is also human right, so that needs to be protected. Identity cannot be disclosed. Interrogation of the victim cannot be done in the police station. It must be done in the residence of the victim and in presence of the parents. In this type of cases, parents must be taken into confidence, or the guardian must be taken into confidence for the purpose of interrogation, for the purpose of collection of evidence or information which will which is required for the purpose of investigation. Now, you will have detailed discussion on these issues in the working session of the workshop. I will only say that the children, particularly the children below the age of 8 years or 7 years, they may not have proper maturity and they cannot distinguish between reality and imagination. So many a time they mix up reality with the imagination, and it is easy to tutor this type of child. So at the time of collection of evidence, recording of the statement, the police officers must keep in mind all these things, and they have to ascertain that the child is speaking the truth, and then the statement should be recorded. And in the end, I will say that, and I believe it, that the only service where one can do for the society to one's heart's content is the police service. So you are fortunate enough to join in the police service. You are getting the opportunity to serve the society, which even the judges do not get the opportunity. Unless the information is placed before us, unless the materials are placed before us, we can't give justice. You are working in the field, you have ample opportunity to give justice to the people. So utilize that opportunity, do justice to the society, and you will have your own satisfaction. When you will think, when you will retrospect, you will find full satisfaction for doing justice to the people. Thank you.
Thank you so much, sir, for that wonderful piece of advice, and also I am sure the audience will take back a lot of what he said in terms of legal issues and the police personnel's activities. May I now request the Chairman of Kolkata Police Law Institute, Learned Commissioner of Police, Shri Rajiv Kumar IPS, to deliver a speech on his account of the Juvenile Justice Act 2015 with his suggestions on better working of the police personnel regarding this act.
Thank you. Honorable Dr. Panja, Honorable Justice Bagh, Honorable Vice Chancellor Professor Bagh, my dear colleagues, the faculty, principal of the KPLI, faculty members, and my dear students of KPLI. It's such a today I have a great feeling on two counts. Number one, this one-day workshop will not only enrich the KPLI, the students of KPLI who will gain about the nuances of Juvenile Justice Act, but also the Kolkata police officers who are here, they will also gain from this seminar. I will just speak in general terms. In ancient times, when a man prayed to God, he wished that when he looked heavenwards and he asked from God, "Oh God, give me victory over all. But I want defeat by my children. I want my children to do better than me." That used to be that is what every one of us want. We want to do well, but at the same time we want our children to do better than us. Individually we care for children, but as a society, as a society, we have not taken good care of our children, the kind of the care which we should have taken. And that is what reflected in the acts which have been passed, the new act which is of 2015. We need to take care of our children in a better way than we are taking today. And that is the theme. I think you will discuss the legalities, you will discuss the procedures, which are very important, but the theme remains the same old prayer, that our children should do better than us, and they will do better than us only if we take good care of them. That's one thought which I'll leave with you. The other was that for the police officers, if we see the act itself, if you'll read the act, you'll see the act itself still treats us like the Lord Macaulay's police force, which does not put too much of trust in a police officer. We need to introspect. Number one, that are we doing enough to earn the trust of the society so that we can come out of that the standard which Lord Macaulay set for the Indian police, or are we doing the same thing, or are we doing something negative, that's why society is not able to place trust. But also the society in large also has to think about it, and I'm sure that there are so many people from other walks of life who will give that can we trust our police force, our officers more than what we trusted them in the past. That's a question which all of us can think about and ponder and can come up with our own answers to it. I'll not take much of your time. It's been a long opening session, and I want to thank distinguished guests and they for agreeing to come here and giving their valuable opinion. Thank you very much. God bless you all.
Thank you, sir. I'm sure we all have collected the food for thought for the day and consequently act. Now, may I please have the faculty member of Kolkata Police Law Institute to hand over the mementos to our dignitaries on stage as a token of our gratitude for their presence with us today. Special guest, Honorable Justice Ranjit Kumar Bagh. Our chief guest, Dr. Shoshi Panja. Our guest of honor, Professor Dr. Bhatt. Our Chairman of Kolkata Police Law Institute, Learned Commissioner of Police, Shri Rajiv Kumar IPS. If I may just add a line about the symbolic understanding of the memento, it's two hands with two playful children. I'm being reminded of we shall overcome someday. So with the juvenile justice system and the children and police personnel working together, we will definitely overcome all the social evils one day. Thank you so much, sir. Thank you, ma'am, for being with us today. I may have the audience to be please seated. We will quickly begin with the next session.